While leaseholders have an obligation to pay the ground rent which is stated in their lease, they may only be liable to do so if it is formally demanded. A formal demand must be made using a Section 166 ground rent demand notice, which has a prescribed format and strict timelines set out by the Commonhold and Leasehold Reform Act 2002. The ground rent demand must specify the name of the leaseholder, the name and address of the freeholder, the name and address of the company or person to whom the payment must be made, the amount of ground rent due, the date by which the leaseholder must pay, and the period for which the payment is due. Ground rent demands can be backdated by up to 6 years. To do so, the demand notice must state the date on which the ground rent would have been payable under the terms of the lease. It is essential that ground rent demands are prepared and served in accordance with the law, as any incorrect information may render the notice invalid, meaning leaseholders won't have to pay.
We can prepare and serve ground rent demands on your behalf. Contact us to find out more.
Before issuing ground rent demands, it is crucial that you read the lease and understand the ground rent obligations and any clauses. Firstly, you'll need to establish when the ground rent is payable. For example, it may be due twice annually or quarterly, in which case you'll need to issue a demand for each payment. Obtaining the correct postage address for leaseholders is also critical, as you may find that they don't actually live in your building, so we advise writing to leaseholders in order to gain confirmation of their current address. It is very common for leases to contain provisions for ground rent reviews. This may mean that you are able to increase the amount of ground rent periodically if you find this to be necessary. Lastly, if leaseholders fail to pay, you may wish to take action against them in order to pursue payment of arrears. This should of course be a last resort, and you should check the leases carefully to determine whether you are allowed to recover any costs from the leaseholder in pursuing the arrears, which is ultimately a breach of the lease. For more expert guidance, please subscribe to this channel, and if you require assistance with any of the topics discussed, please visit our website to explore our range of services.